your fourth and final session. It's on Medi-Cal, which I find to be one of the more interesting topics and not easy to find plain language answers anywhere else. And so we are delighted to have Kirsten Howe, a local estate planning attorney who also does Medi-Cal, special needs, all sorts of things. She is a graduate of UC Hastings and the University of Michigan, Hastings for Law School. She's a member of the Contra County Bar Association and is a member of the Estate Planning and Probate, Elder Law, and Women's sections. And I'll tell you, we've had Kirsten here before on estate planning, and I'll tell you, she can cover this topic. So, without further ado.
Thank you for that lovely introduction. Today we are here to talk about Medi-Cal planning. I need to make sure everybody understands what we mean when we say we're talking about Medi-Cal planning. Medi-Cal is a joint federal and state program. The United States government and the state of California together administer the Medi-Cal program. In other states, it's called Medicaid. Medi-Cal offers a lot of different programs to a lot of different people. When Obamacare was enacted, a lot of people suddenly became eligible for Medi-Cal for their health care. The Medi-Cal that I'm talking about here in this presentation is the Medi-Cal that pays for nursing home care for disabled people over the age of 65, and again, who have limited financial resources. That's always true of Medi-Cal. The typical scenario when we're doing Medi-Cal planning in my office, most often we're working with a married couple. One of the spouses might have a diagnosis of a debilitating illness, Alzheimer's, Parkinson's, MS, ALS, and the couple is worried that eventually that spouse will need nursing home care, and that nursing home care will use up all of the money that the two of them have saved in their lifetimes. And they would like to protect some of their money. A lot of people confuse Medicare and Medi-Cal because they sound very similar, and in some limited respects they do cover the same things. Medicare is a federal program. The state of California is not involved in Medicare, and Medicare is an entitlement program. All you have to do to be eligible for Medicare is turn 65. Medicare will pay for nursing home care while you are rehabilitating. In the old days, we would go to the hospital and we'd have our surgery and we'd stay in the hospital for 2 weeks to recuperate. Now if you go into a hospital for a surgery, they'll discharge you a day or two later to a skilled nursing facility, and that's where you do your rehabilitation. Medicare will pay for that. Medicare stops paying when you are no longer making progress. Medicare will cover up to 100 days of what we call rehabilitation. So that's where the two kind of overlap, because if you are in a nursing home because you're rehabilitating and you reach the end of your rehab period, but you still can't go home because you can't take care of yourself, then you either private pay or Medi-Cal will pick that up. And we're going to talk about how we get to the point where Medi-Cal will pay for our nursing home care. What I'm going to cover is the rules of eligibility for Medi-Cal. I'm also going to cover some other concepts in the Medi-Cal realm that we always have to keep in mind. I'm going to make a comparison between the current Medi-Cal rules and the future Medi-Cal rules that we know are coming, we just don't know when. And then I'm going to talk about how we do the planning. What are some of the tools that we use? All right, so you have to be eligible in 3 different ways. You have to be medically eligible, and that simply means that your doctor says you need to be in a skilled nursing facility because that is the level of care that you require. The second 2 prongs of eligibility is you have to have low income, you will not be eligible for Medi-Cal if your monthly income is more than the cost of the nursing home, which here in the Bay Area, they are very expensive, so a lot of people are eligible on the income. We're not usually as concerned about planning for income eligibility. Most of what we are doing when we're planning Medi-Cal is we're trying to get the assets to where they need to be in order to be eligible. For Medi-Cal purposes, our assets are divided into 3 categories. We have exempt assets. Exempt assets are assets that you are allowed to have and still be eligible. We have unavailable assets. That's just a funny term. Unavailable assets are treated the same as exempt assets. And then we have everything else, which is non-exempt assets. The basic exempt assets that everyone's allowed to have, you're allowed to own your home. It doesn't matter how much you paid for it or how much it could sell for. You're allowed to own it and still receive Medi-Cal. You are allowed to own 1 car. You are allowed to own a small life insurance policy, a small whole life policy. Term policies are not assets, so we don't worry about term life, but we worry about whole life. So you can have a prepaid burial contract. If I'm the Medi-Cal applicant, I am allowed to have $2,000 in other assets. So that could be $2,000 in my bank account. It could be $2,000 worth of Apple stock. It could be a $2,000 car. As long as it's less than $2,000, I can have that as the applicant. And then my spouse, this is my spouse here, what's your name?
George.
George, my spouse George, in addition to my $2,000, he gets to have $120,900. So that's what the 2 of us can have together. House, car, a little bit of life insurance, prepaid funeral, my $2,000, his $120. Those are considered exempt assets. In addition, George's IRAs and 401ks are exempt assets. A lot of people ask me, well, wait a minute, this is my separate property. I had this before we got married, this rental property that I had before we got married. That's my separate property, that shouldn't count. No, it counts. Everything that the married couple owns, regardless of whose it is, we're going to look at that when we're doing Medi-Cal planning, and Medi-Cal's going to look at it when you submit your application. So separate property, community property, doesn't matter. So those are the exempt assets. That's what we're allowed to have. The unavailable but treated as though they are exempt are my retirement assets. I'm allowed to keep my IRAs and my 401k as long as I have it structured to pay me out over my life expectancy. Some of you in this room are already doing that with your IRAs, your 401ks. If you're over the age of 70 and a half, you are taking required minimum distributions from your IRAs, and it's the same concept. But if I'm applying for Medi-Cal, I'm required to get that started even if I'm not 70 and a half. Some annuities are also considered unavailable assets, and they are therefore treated like exempt assets. Annuities are very complicated assets. Every single one of them is different. So we're not going to talk about those. You just need to remember, oh, annuities, I know there's something about those. And when the time comes, if you're doing Medi-Cal planning, your attorney will want to read that contract. We are allowed to have all of that and still be eligible for Medi-Cal. Anything else we have will make us ineligible. So that's where the planning comes in. What do we do with this extra stuff that we have? So aside from those eligibility rules, which I just laid out for you, there are 4 larger planning considerations we have to keep in mind. We have share of costs, we have look-back period, we have penalty period, and we have estate recovery, and I'm going to cover each one of those separately. So share of costs, you are required to help Medi-Cal. Medi-Cal is going to require that you use your income to pay for your own nursing home care. So in the scenario that I laid out for you earlier, where I am applying for Medi-Cal, I'm the one in the nursing home, my husband's not in the nursing home, and let's just say I have $2,000 a month in Social Security, and that's my income. I don't have any other income. $2,000 a month in Social Security. I will be required to use all but $35 of that to pay for my nursing home care. That $35 is my personal allowance that Medi-Cal lets me keep so that I can buy candy, or I can go to the movies, or I can get my hair cut. Yeah, good luck with that. Medi-Cal will pay the rest. So if my nursing home bill is $8,000, $1,965 of it is coming from my Social Security income, and Medi-Cal will pay the rest. However, I have my spouse at home, and we are worried about him as well. My spouse is entitled to what we call a minimum monthly maintenance needs allowance. This year, 2017, that amount is $3,023. So what does that mean that he's entitled to that? So I have $2,000 a month in Social Security, and let's say that George also has his own Social Security, $2,000 a month. His income is $2,000, but he's entitled to $3,023. He's not getting enough income as far as Medi-Cal is concerned. What that means is that instead of me keeping my $35 and giving the $1,965 to the nursing home, I'm going to give $1,023 to George so we can bring him up to his $3,023. I keep $35, I give him $1,023, I give the rest to my nursing home, and Medi-Cal pays the difference. But what this means is he is allowed to have that much income. If we together don't have that much income, it's not that Medi-Cal is going to cut him a check. Medi-Cal only pays for nursing home care. So whatever our income is, we can keep as much of it as we need to get him to $3,023. We can keep more than that if his income is greater. His income does not enter into this equation at all. If I have $2,000 in income and he has $10,000 in income, he gets to keep all of that. I'm the one who's applying for Medi-Cal. His income doesn't matter. His assets matter. The second of the big concepts we need to keep in mind is the look-back period. The look-back period is a time period from the day that we submit our Medi-Cal application going backwards in time, either 2.5 years or 5 years, depending, and I'll explain the difference. Going backwards in time, we have to disclose on our Medi-Cal application any transfers that we made during that look-back period that were for less than fair value. So what I'm going to tell you about is what does that mean? If I hire somebody to put a new roof on my house and I pay him $20,000 and he puts a new roof on my house, I gave somebody $20,000, but I got $20,000 worth of value back. So that is not what I'm talking about. When you spend your money and you get something in return, that's not what I'm talking about. You don't have to disclose those things. It's when you give somebody money and you don't get anything in return. Some of my clients are on an annual gifting plan with their children and grandchildren, and every year they write a check for $14,000. That's an example of a transfer with no value coming back, and we would have to disclose that to Medi-Cal. So if you make a gift to your children, or your grandchildren, or your friend, or anybody, you make a gift of anything worth value, we have to disclose that. Another example is very common. The grandparents say, we're going to take a cruise and we're going to take the whole family with us. All the kids, all the grandkids, we're all going on a cruise and we're going to pay. So the grandparents' 2 tickets on the cruise ship, they got something of value for that. And you could argue that they got value for the other tickets. but they didn't get monetary value. They got emotional family value. They didn't get anything in return. They bought those tickets for somebody else. That's an example of something we would have to disclose on our Medi-Cal application. So anything that we transferred like that, you give your child a car and the child doesn't pay you for it, or you're going to disclose that on your application. If it took place in the last 2.5 or 5 years before you filled out your application. 2.5 is for giving something to a person, and the 5 years is for transferring something into a trust. Okay, the next big concept is the penalty period. Now this slide is where everything is going to, I hope, be pulled together and it'll all start to make sense to you. The penalty period is the way that Medi-Cal punishes us for making those kinds of transfers that I just talked about. They don't fine you. You don't have to write them a check when you make the transfer. They punish you by giving you a penalty period. So it's kind of like hockey. If you are playing a hockey game and you do something that the ref doesn't like, you have to go sit in the penalty box for some number of minutes. And Medi-Cal is similar in that regard. If you make a transfer that Medi-Cal doesn't like, even though when you apply for Medi-Cal you are eligible because you have no assets, no income, you're eligible, you're going to be penalized, and Medi-Cal says, we know you're eligible, but you're going to have to wait 6 months before we will pay for your nursing home care. That's how the penalty period works. So how the penalty period is calculated, this number up here that you see, the average private pay rate, 85.15, that's California 2017. We take the value of the gift or transfer that was made. So let's just say we have here my son Harry, and I, as the Medi-Cal applicant, 2 years ago, I wrote a check to Harry for $85,000. I just gave it to him because I wanted him to have it. It doesn't matter why I gave it to him. I gave it to him and he didn't give me anything back. He didn't sign a promissory note, nothing. It was purely a gift between me and my son Harry. I'm going to have to put that on my Medi-Cal application, so they'll know that I did that. And what they will do with it is they'll take that $85,000, divide it by that number. So now you see why I picked $85,000. It's kind of a weird amount. 85,000 divided by 85.15, we come up with about 10. That is my penalty period, 10 months. So I went to a good attorney, I got myself eligible for Medi-Cal, I filled out the application, and Medi-Cal's response is, great, you're eligible, but you're going to have to wait 10 months. However, I told you, I made that gift to my son Harry 2 years ago. Under the current law in California, your penalty period starts on the day you make the gift. So since I made that gift to Harry 2 years ago, and my penalty period is only 10 months, I've already served it and I'm out of the box, I'm ready to go. I get my benefit. Here's another example. Let's say I made that gift to Harry 1 month ago, but instead of making an $85,000 gift to Harry, I gave Harry $42,500, and I gave my other son Jack $42,500. 2 smaller gifts. What happens with those? If we divide each one of those by my number up here, 85.15, we come up with 5. That means I get a 5-month penalty period. And the thing that's unique about California law, because we're still on the old rules, is that each gift, Harry's gift and Jack's gift, gets their own penalty period. They start running as soon as I make the gift, and they run together at the same time. So even though I gave away $85,000, which could have been a 10-month penalty, by cutting it into 2 gifts, I get a 5-month penalty. Now, that's a planning opportunity. So we can make a series of small gifts in order to minimize the penalty period. The other thing about current California law is that we only get a maximum penalty of 30 months. Under the future law, there's no limit. The last of the big four concepts we need to keep in mind is estate recovery. Estate recovery means if I receive Medi-Cal during my lifetime for nursing home, when I die, the state of California is entitled to be paid back, and they will send a bill to my executor, and it's all itemized. Here's how we spent that $165,000. And the law that was passed at the beginning of this year narrowed down what the state can grab. Now, only the probate estate can be grabbed for estate recovery. So if you don't have a revocable living trust estate plan right now, you better go get yourselves one, because anything in your trust is off the table for estate recovery. The assets that you have in accounts that get paid on your death to another person, such as an IRA or a 401k, those are not part of your probate estate either. Those are good. Your life insurance policies, if you have a beneficiary designated that is other than my estate, that's not going through probate either. So this was, in my opinion, a very, very generous change in the law. It used to be, remember, your home is an exempt asset. So a lot of people would have a home and they go on Medi-Cal, and then they die, and now the home has to be sold to pay Medi-Cal back. But the state of California just gave us a way around that. Just put your home in a trust. No problem. So now you have an understanding of the rules. You know what our goal is. We are trying to get me and George to one house, one car, one little life insurance policy, his IRAs, my IRAs, $2,000 for me and $120 for him. That's our goal. How do we get there? One very common way is we convert our non-exempt assets to exempt assets. So a non-exempt assets would be a bank account that's too big. I have $200,000 in the bank account. I'm only allowed to have $2,000 plus $120,000. So I have about $78,000 too much in my bank account. What am I going to do with that? That's a non-exempt asset. What I could do is I could pay down my mortgage. I could take that $78,000 non-exempt, pay my mortgage on my home, and it now becomes an exempt asset. Okay, I just bought some more home equity, which is exempt. That's one strategy, turning non-exempt to exempt. Doesn't even have to be paying down a mortgage. It could be, let's add a bathroom onto this house. We always wanted a third bathroom. Let's put on a new roof. Let's paint it. Or this car is 15 years old and it has 250,000 miles on it. Let's buy a new car. Get rid of that old beater. Buy a nice new Subaru. It's my favorite car. So converting non-exempt to exempt. That's one strategy. Gifting. You remember my example. I could give money to my son Harry. I could give money to my son Jack. I could give it to all kinds of people, whoever I'd like. But then it's gone. This is something you need to remember. When you give it to somebody, you don't get to take it back, even if you're their mother. The other thing to consider when you're giving your money to somebody with the idea that because you're their mother, they will give it back when you need it, is once you give it to them, legally it's theirs. And so my son Jack is graduating from medical school next year. Doctors get sued for malpractice. Now what happens if I give Jack my $42,000 and he gets sued for malpractice and his plaintiff takes that $42,000 away from him? I can't stand there and say, no, you don't understand, that's my money. No, it's his money. So asset protection is a big deal when we are giving our money away with the hope that we'll eventually get it back. Same with Harry. Harry, he's a great kid, but he's not the best driver. Harry could get in a car accident and he could be sued by his plaintiff, get a judgment, and now there goes my $42,000. Again, it belongs to Harry as far as the law is concerned. So giving your assets to family members is risky, which is the reason why we want to use an irrevocable trust. I make Harry the trustee of my trust because Jack, he's a doctor, he's going to be way too busy. If I need money, or actually it's going to be George because I'm in a nursing home, I don't need money. George needs money. He calls up Harry and says, I want to take a vacation. I need $5,000. And Harry says, sure, okay, no problem. So Harry writes a check out of this irrevocable trust. He writes a check to Harry, who is the beneficiary of the trust. Harry's the trustee and the beneficiary. He writes a check from the trustee Harry to the beneficiary Harry, and the beneficiary Harry puts it in the beneficiary Harry's bank account. And the beneficiary Harry writes George a check for $5,000. This is how these trusts work. George and I cannot touch that trust. If we were, it would be a non-exempt asset because it's out of our control. It's not even our asset. So you see how these irrevocable trusts work? They require not just a written trust, they require trust. The family kind. Sometimes we buy annuities to convert money from non-exempt into unavailable and therefore exempt. That's a complicated thing. Again, annuities, I don't want to get into that. If somebody suggests to you, why don't you buy an annuity and this will make you eligible for Medi-Cal. Make sure you talk to an attorney. Don't just talk to the annuity person. Make sure that somebody who can read that contract and give you good advice about it actually looks at it. There are annuities that work that way and they're great, but you need to make sure you're getting that kind. Okay, and then the last thing that we sometimes use is when we have a married couple, and we'll go back to my example where I have $2,000 in Social Security income and my spouse George, he has no income. He never worked a day in his life, not getting Social Security. So now, $2,000 is all we have coming in every month. Remember, I get to keep my 35. George is entitled to that MMMNA, 3023. So he'll get the rest of mine, 1965, but he's still short. Where is that money going to come from? One thing we can do is we can go to court, we go to the probate court and we say, Your Honor, this is the situation. He doesn't even if I give him all my extra income, he's not going to have enough. We need you to let us keep this brokerage account that we have that's a non-exempt asset because it's too much, but it's generating $1,000 a month in income for us. So we need you to tell us it's okay for us to keep that extra money because we need the income. And that's called a 3100 petition, and we do that all the time in order to, usually it's because the income is a problem. Maybe the couple didn't really save for retirement, but they invested in rental properties. So they need to keep those rental properties. Those are non-exempt assets, but it's what gives them their income in retirement. And so we need to ask a judge to help us keep that. And if the judge issues that order, which they usually will if you write it correctly and you're not being a hog, we'll get that order and Medi-Cal has to honor it because it's a court order. So that's kind of a summary of the tools that we have available to us. There's just a couple of things I wanted to emphasize to you. One, really the main thing is if you become incapacitated, all of this planning that I talked about becomes extraordinarily difficult, if not impossible. My advice to you is if any of this resonates with you, if you're worried about it, go to your estate planning attorney and make sure that in your estate planning documents you have given somebody else in writing legal authority to do this kind of planning for you. Even your spouse is not allowed to do this kind of planning with your assets unless you've legally authorized it. And most run-of-the-mill, regular, plain vanilla estate plans do not. This is a special kind of power. We don't just give it away willy-nilly without talking about it. And so if you don't remember having that conversation with your attorney, chances are you didn't put that into your estate plan. So I encourage you, if this worries you, to talk to your attorney about that. Thank you very much.
On behalf of the Library Foundation, I want to thank you for this presentation. I've sat through continuing professional education a couple of times on Medi-Cal, and I got to tell you, this is the most plain spoken, direct that I've ever heard. And I would also invite you to take a look at Kirsten's website, absolutetrustcouncil.com.